In the previous lesson, what we did was examine the fundamental principles of the UK's constitution. And we did so from a sort of generic introductory perspective. We talked about the concept of the rule of law, we talked about the concept of parliamentary sovereignty, and we also talked about what is going to be the first of our concepts that we're going to explore in more detail, this idea of the separation of powers. Now, ultimately, what we're going to do in this video is start to look at these principles in more detail. So we're going to take the first of the fundamental principles of the UK Constitution, this obviously being the idea of the separation of powers. I'm going to talk about how this is operationalized within the UK's constitutional framework. So fundamentally, the separation of powers is quite an old concept. To an extent, you may argue that it has its ancient and Aristotelian origins in some regards. But in terms of its modern conception and the way in which we can understand the separation of powers today, we can really date ourselves back to the more Enlightenment philosophers that exists. For example, provincial French nobleman Montesquieu argues that ultimately, when legislative power is united with executive power in a single person or in a single body of the magistracy, there is no liberty, because one can fear that the same monarch or senate that makes tyrannical laws will execute them tyrannically. Nor is there any liberty if the power of judging is not separate from the legislative power and the executive power. If it were joined to legislative power, the power over the life and liberty of the citizen would be arbitrary, for the judge would be the legislature. If it were appointed to executive power, the judge could have the force of an oppressor. This is really a passage that explains what the importance of the separation of powers ultimately entails, why the separation of powers is an important concept. Because if power was not separated, if you have these distinct concepts when it comes to government structure, the idea of making laws, executing laws, and upholding laws, and that they were all united under one single unitary body or one single person, then you have this idea of tyranny. You have somebody who is able to make a tyrannical law and then also execute the tyrannical law and have no pushback in doing so. When we have a separation of powers and when we have checks and balances on each of the branches of government, you have the ability for certain branches to potentially pass tyrannical laws, but then for other branches to check that authority and to ensure that those tyrannical laws are not executed or not upheld, for example. And so really the common understanding here is the rationale behind the separation of powers. And we can see the traditional rationale in this formal passage. The aim here is, of course, to preserve the liberty of the citizenry by distributing state power across various and separate distinct branches of government. Remember that what is happening when we talk about the relationship between the people and government is the people are delegating to the state a significant amount of authority. We are, as people, delegating to the government the ability to make laws that we have to follow, to uphold those said laws, and to hold the people to account if those laws are broken. So the general idea here is, well, we are trusting in the government a certain amount of power. And so in order to preserve the liberty of the citizenry, that power has to be checked. And one way in which it is checked is through the separation of powers, by distributing authority across different branches. Another way, of course, is through democratic election, as you can probably understand. So the result of which is that no one branch becomes too powerful, and so the insurance here is that we do not have the suppression of civil liberties. So given that that's the rationale for the separation of powers, what do we look when we see the separation of powers as applied to the United Kingdom? Well, ultimately, the traditional understanding of the separation of powers entails a delineation of authority between three major branches of government. We have an executive branch of government, we have a legislative branch of government, and we have a judicial branch of government. And this is what is considered to be the traditional understanding of separation of powers, at least from a level which is from the same level, should I say, because in some cases you have a federal state where not only is power separated horizontally across three different branches, but it is also separated vertically between federal, state, and local government institutions. In the US, we have these three branches of government, for example. At the federal level, so making it clear that we're talking about this at the federal level, The US Constitution outlines three distinct branches of government. We have the executive branch, which is representative at the federal level with the president and the White House mostly. We then have the legislative branch, or the legislature. Again, this is represented by Congress, the houses of Congress, the House of Representatives and the Senate. And then you have at the federal level the Supreme Court, which represents the judiciary. And the Constitution outlines that each of these three branches will have the power to check all of the others. And it also makes it very clear that these three branches are clearly distinct and separate branches. You cannot be, for example, a member of the executive and a member of the legislature at the same time. Sometimes you have members of Congress who want to run for president. They would have to resign as Congress or as Congress people, or at least don't run for re-election during a congressional election, in order to then run for presidential election instead. And if they fail, they can go back to Congress, but they cannot hold the position of being a member of Congress and a member of the executive at the same time. This strict and constitutionally mandated separation of powers, however, does not exist when we apply our principles to the United Kingdom. Because one of the reasons why is because we have an uncodified constitution. We don't have a specific document which outlines the exact ways in which the different branches of government have relationships with each other. Instead, we have what is sometimes described as a partial separation of powers. So rather than having, for example, an executive and a legislative branch which are both completely distinct and separate, these institutions are in fact fused. So we have the fact that the government, the executive branch, sits in Parliament and has parliamentary legislative authority. It has the authority and contributions to the passing of law. Now, this is not to suggest that they are so merged that we cannot delimit them. We cannot delineate between the government and the legislature, or between government and parliament within our system. But it's just that they perform similar functions. They perform the same functions. They sit in the same institution. And so, in the next lesson, we'll go through essentially the ways in which the separation of powers is applied to the UK system. We will talk specifically about this idea of a fusion of powers between the executive and the legislative branch. We'll talk about the changes in separation of powers when we looked at the ways in which the judiciary has become separated from this legislative centre. And we'll also talk about the role of specific institutions, such as that of the role of the Lord Chancellor.